Thank you, Abhishek, for giving me this opportunity in the end of the panel discussion. And it has got its advantages as well as disadvantages. Advantages in the sense that most of the people have given their insight about not only the delays, the conflicts, and the resolution. And I can, kind of sum up that though your specific question to me is how to counter the delays and what are the proposed steps, either even by the government, by IBBI, whether there are any papers presented. So according to me, there are 5 challenges. We have to first identify what are the challenges in dealing with the, resolving the issues relating to IBC in realty sector. So 5 important key points which we have to think about is limited scope of project-wise resolution. Because there, moment a corporate data goes into IBC, the fight starts as to which project and how to correlate the first project and how to entangle the promoters or their other projects so as to ensure that there is a successful resolution. That's the first point. And then what are the benchmark and a watertight sort of SOP which removes the conflicts, which does not overlaps the powers, which does not overlaps the understanding. According to me, that is the first point. The second is limited role of authorized representatives. It was rightly pointed out by Anu on the other side and given insight by you. What happens, it's not necessary that all home buyers are very aware of this process, and authorized representative, as we all know, was included in the later part. You have to have a minimum number to, authorize the authorized representative. I understand it's 10% or 100. And then the conflict starts. If suppose there is no proper instruction to the authorized representative whether to vote or not to vote, this is where the potential conflict between RP and authorized representative starts. So that also has to be streamlined. There has to be SOPs for that what are the rights and interests, whether the rights, because ultimately we have to be mindful of the fact that the rights of home buyers, because the realty sector is dominated by home buyers, and it has already been upheld by all our courts, adjudicating authority, appellate authority, as well as Supreme Court, including the latest one which the Honorable Chairperson of NCA LAT was mentioning, is the Umang judgment, which has laid down that the interest of home buyers are paramount. So that is the aspect, and as to how to strengthen, the hands of authorized representatives so as to reduce the conflict between so that's another part. Then the third part is asymmetrical, the database. As rightly pointed out by the senior colleague on the other side, senior colleague Mr. Datta, that asymmetrical information is the one which creates a lot of confusion, lot of delays. For example, some of the realty company which we have also been dealt, and we realize that there are no information available at all with respect to the corporate debtors, books of accounts. So therefore it becomes very, very difficult on the basis of information available or books of accounts as to how to collate the claims. So until unless the home buyer comes, and as we know, home buyers may not be necessarily part of that geographical area. He may be, in some other part, whereas the law provides that the publication of that particular part has to be there where the registered office of the company is or where the project is situated. So that those are the asymmetrical, the information that needs to be collated. Having said all of that, now what is how to reduce the delay? I was recently reading, the discussion paper introduced by the IBBI, and I have noted some of the points. Those are important points. I do not know whether that will be implemented by way of bringing the legislation, or by way of the notification, or by way of the judicial intervention. The first is inclusion of land authorities in COC meetings. They may not be having, the right to vote, but their inclusion right from the inception, because that is one of the most important point. They never filed their claim on time, and there was a lot of time wasted with respect to their status, whether they are the operational creditor, whether they are the financial creditor, and they will not file their claims on time. So how to resolve all of that and to reduce the delay? So this is how the discussion paper of IBBI has introduced that point, that let land authorities be included in COC, so that if there are any problems, because this was also pointed out by Mr. Datta, and rightly so, that what happens, they cancel it during the CIRP process. That takes a lot of time for RP or the authorized representative together to go to the authority, represent as to how to, get the NOC of the land, so that the project can be completed. So that is one aspect which needs to be, taken care of, and that a discussion paper is in fact very, very helpful, and that should be either included in the IBC court by way of notification, clarifying the existing sections, or maybe bringing a new section. Then that also includes how to handle the already cancelled. Suppose the company comes in CRP process, and the landowning authority has already cancelled it because there is no payment. And we have seen it across Noida Authority, Greater Noida Authority, Maharashtra Authority. They all cancel it, and they have got a huge claim amount. So how to deal with that? And some of, like, I was dealing with one of the real estate projects, IBC, in NCLT Mumbai, and there they include it as a financial creditor, that you have to include it as a financial creditor, whatever claims are there, unless you pay the complete amount, there will not be any no objections. So for that it was filed. That actually delayed the whole process for 2 years. The matter went to writ court. Writ decided in favor of Maharashtra state. Then matter finally came to Supreme Court. Then without the issue got resolved, it was withdrawn, saying that they will be filing the claim. So whole host of these issues, requires consideration, and some robust system has to come out with that. And of course, by way of either the discussion paper, putting it before the government, and because see that according to me, if it comes through the government, that will be the best way. Then the attribution to the delay would only be the adjudicating authority and the person who is bringing the company into IBC, without getting into the writ court and then finally going to the Supreme Court, etc., etc. Then another important point, according to me, is improving representation through facilitation for large creditor classes. That resolution really takes a lot of time, and that delays the whole process. So therefore, if there are the classes have to be defined, and there should be particular form for each of the classes, and it can be done. It's not very difficult situation, because for the classes like operational creditor, initially the form was a particular form, and for the financial creditor there was a form which needed the explanation, etc. Similarly, the classes of the creditors through the IBBI processes can be done, and the particular forms can be introduced. That, according to me, can be reduce the delay. Then third is the disseminating COC meeting minutes to all real estate creditors. Most of the time we see the fight, we are not aware what is happening, now we had no information, and therefore the information is the hallmark for the purpose of completion of the project. Therefore I should be provided with the information, and that really delays the whole process, because the single home buyer can also come to the court on the basis of non-information, and therefore they are not able to really decide whether they have to go ahead with the resolution or they do not have to go ahead with the resolution. So that these conflicts, are important, and most important is the conflict between the authorized representative and the RP. Because what happens, as rightly pointed by Anu, the hallmark of whole host of the problem is the bona fide intent. If there is a mala fide intent and the promoter or any other person who knows as to how to twist the law in their favor, because genuinely in India promoter thinks that it is the company is his baby and he can delay it so as to he can finally take it over, if not through the resolution process but ultimately through the liquidation process. Because most of the realty sectors I have not seen having the institutionalized financial creditors. They normally raise the funds through the home buyers, and we have seen many of them, and so therefore there is no applicability of 29A, because there is no NPA with respect to them, and there is no time lag of 1 year. So they are free to introduce himself or itself, as a resolution applicant, and if things it ensures that resolution doesn't take place and goes into finally to the liquidation. One important aspect, Abhishek, which I wanted to point out, in the realty sector, what happens sometimes the promoters, through its related party associates, brings some funds and then create a security. And that actually takes a lot of time in deciding the whole issue, because now the issue is if the associate company is there and there is a related party, but the security has created, then how the security can be cancelled because security is created by way of a third party. That actually takes a lot of time in implementation of IBC. That aspect should also be considered by the authority. There should be some discussion on this aspect by IBBI and to be brought before the government for the resolution of these. These are the short key issues according to me. I mean, if we are able to navigate, we will be able to find some sort of a solution in the coming future.
Right.
Thank you.
Thank you, ma'am, for giving us all these insights into the possible solutions. And one solution which I have taken note of, and in fact I think as in the discussion paper with our chair permission, we could probably have a webinar on this and then give the representation that these land owning authorities or the landowners should be part of the process, whether be part in the COC as an observer or should be part in the process with purpose of negotiation, so that the ultimate goal of achieving a resolution is achieved from the beginning itself.